afternoon, everyone, and a warm welcome. Everyone's joined us today for our fourth COVID-19 employment webinar. This will have a particular focus with respect to issues arising in the oil and gas sector. I'm Sean Saluja, and I'm a partner in the Burness Paull employment team. I'm joined today by my colleague Lynne Gray, who's also a partner in our HSCC team. And the reason for that is because a number of the issues that we are advising and assisting clients with in the sector when grappling with these difficult aspects cross between both employment and health and safety. We do appreciate that you're all extremely busy, and more than ever just now, you need us to be there to support you, and we do hope that this session helps with that. Before we kick off today, I just wanted to mention a couple of housekeeping matters if I can. Firstly, could I please ask that you all select the mute button to limit any background noise. On joining the webinar, the mute option is automatically selected, but if you could just make sure that the mute function is on, that would be great, and thank you. There's an option to ask questions as the session goes on, so please feel free to ask via the WebEx chat function. You could either send the question to everyone to see, which is probably the best thing to do, and we have also received a few questions in advance, which I'll try to address as we go through. If time permits, we'll also try to deal with questions which are raised throughout the session. If we're not able to do that, then we will follow up separately with a summary. Given the numbers attending, we're not going to open the floor for a general discussion at the end, so do make use of the question function, which we'll either address today or come back to you separately on. Just to be clear, all questions will be anonymised so we can record the webinar and distribute afterwards. We're also planning to issue that note to cover the issues which we can't manage to do this morning. As I've mentioned, the session will be recorded, and we will make that available to everybody afterwards. If you have any questions about that, you can also check our privacy policy on the Burness Paull website. The session today will finish at 1:30 p.m. In the previous sessions, which focused on employment, we covered predominantly key questions arising on SSP and pay. A note from that session is available on our website. Today's topics are intended to deal with more recent developments, and I'm sure you'll all agree that one day in the current scenario feels like a lifetime. It is an extraordinary period in which we are currently working, when legislation which might take several months is having to be introduced in a matter of days. And announcements from government at the highest level, which affects our daily and working life, are happening on a frequent basis. When we were putting together the topics we've been dealing with over the last week or so, there were a number of them, and obviously part of that was the job retention scheme. Given that just last night there has been detailed guidance issued by the government on the JRS scheme, I'm now going to focus on that as the main part of today's update, and again, time allows, to then move on to the other issues which we've been dealing with in the last week. So if I may, we'll move straight on to the coronavirus job retention scheme, or what's otherwise referred to in recent updates as furlough leave. The government made a clear pledge to assist both businesses and employees during the coronavirus pandemic. The Chancellor announced the scheme on 20th March. This is formally referred to on the government website as the Coronavirus Job Retention Scheme, and I'll just refer to it in this presentation as the scheme. As we know, the basic purpose of the scheme is to allow employers to apply to HMRC for a grant for up to 80% of pay, subject to a cap for employees who are unable to perform their work due to the economic impact on their employer and who would otherwise, as a result, have been made redundant. Such employees in UK parlance would normally be referred to as having been laid off, i.e. effectively placed on unpaid leave, really as an alternative to redundancy, with a view to that person returning to their normal work and pay when the period which was causing the economic hardship subsided. Furlough leave is a US expression and is essentially the equivalent of what we would use in the UK as layoff. The scheme basically allows employers and employees to agree a variation to layoff, whereby instead of receiving no pay, which would be the normal situation in layoff, the employee receives a pay up to a limit from HMRC, which the employer can then choose to top up. Now, this is a very ambitious and welcome scheme, both for employers and employees in the current climate. However, the detail of the scheme is critical, and guidance, as I say, which was promised, literally has now just come out and was released last night. That guidance gives greater clarity over many questions which have been raised from the Chancellor's initial announcement a week ago. We'll also be issuing today a full updated advisory note taking account of this detailed guidance, which I'm sure that you will all find to be very helpful. It's not entirely clear at this stage whether the government also intends to issue further legislative provisions or rely on the guidance only. We'll have to wait and see. I'm going to set out a summary of this scheme and touch on a number of aspects which affect the oil and gas sector and which we have seen in questions which have been raised so far, both in terms of this preparation for the webinar and also generally. The government anticipates that the scheme will be up and running formally by the end of April, and that employers will receive grants and payments into bank accounts at the beginning of May. That in turn leaves a number of key issues for employers to consider if immediate funding is an issue, which I'll come back to cover in this summary. The essential way in which the scheme works is that employers apply to HMRC for a grant to cover the lower of 80% of an employee's regular wage, or £2,500 per month. The employer may also claim for the associated employer NI contributions and minimum enrolment employer pension contributions for the employees who are not working and placed on furlough leave rather than be made redundant. And that was a key clarification point that the government has made clear last night. In terms of employer coverage, the intention is for this to be unrestricted in terms of sector or economic and social criteria. The guidance confirms that it covers any UK organisation with employees which have a PAY payroll scheme in place as at 28th February 2020 and also have a UK bank account. One specific question which has come up from an oil and gas sector's perspective is whether this scheme covers employees who are employed through a non-UK entity and where the business operates effectively an overseas payroll. The guidance confirms 3 employer criteria which must be met, being firstly that they are a UK organisation, secondly operating PAYE, and thirdly having a UK bank account. Many businesses will operate structures deliberately so that they are not classified as having a UK presence or a UK business. For that reason, overseas employing entities will find it difficult to meet the scheme criteria, but each circumstance will need to be carefully reviewed and individual advice taken. A second question is which employees are covered by the scheme. It is clear from the scheme that the government intends the scheme to apply where there is effectively an agreed leave of absence as an alternative to redundancy. This means that no work must be done by the employee during the furlough period due to the workplace closure or other economic impacts on the employer associated with the crisis. It is similar in nature to a career break, with the intention that the employee will eventually return to work and receive their pay as normal. The basic intent of this scheme is that it covers employees who, in the absence of being furloughed, would be made redundant as a result of the impact of the crisis. So it's clearly an alternative to redundancy. One question which has been raised is whether there are any particular redundancy scenario in the sector which is being caused by a reduction in oil price rather than the coronavirus itself. There is likely to be some form of declaration that an employer will need to sign off on when making claims to HMRC. It would seem to us to be a very fine distinction between oil price reduction and the coronavirus when it comes to the reason for redundancies. The key criterion is likely to be a declaration that the employee would otherwise be made redundant, rather than a close examination of the precise reasons, although the extent of any declarations or form that requires to be completed is yet to be seen. The scheme would appear to apply to employees rather than in terms of potentially wider definitions. However, helpfully, the guidance expands upon what they mean by employee, and I think that we can take it to mean that any person who is on a PAYE structure will be covered. So it covers full-time, part-time, 0 hours, flexible working, and those who are employed through an agency. For those who are not paid through PAYE, as we know, the Chancellor has also introduced specific measures for the self-employed part of the workforce in a separate announcement on 26 March, the details of which are also awaited. To be eligible employees, there is a very clear criterion that you must not work for the employer during the period in which the employee is furloughed or laid off. The scheme therefore rules out anybody who has agreed to work shorter hours and to receive lower pay. They will not be covered by the scheme. One question which has also been asked is whether employers can furlough part or all of their workforce. The guidance doesn't provide any information on selection, but it is clear that it is permissible to furlough part of the workforce. We would suggest that employers take advice on this, but it should be approached potentially in the same way that you might look at selection for redundancy as to who may or may not be furloughed, and also be mindful of equality and discrimination laws when it comes to making that decision. But you can, in principle, furlough part of the workforce. To be eligible, employees must be furloughed for a minimum of 3 weeks. Again, a sector question which has been asked is whether you could potentially rotate workers between furlough and non-furlough, perhaps on an equivalent 3 weeks on or 3 weeks off rota. The guidance does not prohibit this, and again, in principle, it should be possible to do this, but bearing in mind that the minimum period to be on furlough is 3 weeks. It's also a situation where you need to carefully consider it and take advice, but in theory, it should be possible to arrange a scheme such as that. Which employees are not covered by the scheme? The scheme only covers those who are on the employer's payroll as at 28th February 2020, and therefore does not cover anyone who has started work after that date. Anybody starting after the 28th of February will not be covered. Employees who are absent from work as a result of self-isolation or social distancing and who are eligible to SSP are not covered. So anybody who is eligible for SSP is not covered. Also, those working at home and shielding in accordance with government guidance on that basis would be covered. So you could technically furlough a person in that situation. It's only a person who's receiving SSP who is not covered. Any employee who can do their job from home, even if their normal workplace has been shut down, is not covered because that person is continuing to work. There was some discussion as to whether or not the government might extend the basis of who may be covered by furlough, taking account of childcare issues, but that has not happened. And also, as I've already said, any employee who is on reduced hours or pay and is still working is not covered. Next question to be asked is exactly how is the grant calculated? For salaried staff, this is based upon the employee's actual salary before tax as at 28th February 2020. The grant is the lower of 80% of that salary, or £2,500 per month. Now, specifically, again, this has come out in the guidance, any fees, commissions, or bonuses are not included in the calculation. For employees who are not salaried and whose pay varies, there is detailed guidance as to how you carry out an averaging in determining the amount of the grant that can be claimed. And I won't go into that today because there are quite technical rules, but it's a form of averaging over a period. Employers who then know how much they are claiming will then work out the amount of employer NI and the minimum automatic enrolment employer pension contributions which they can claim in addition. If an employer is eligible for the grant, HMRC will pay via a BACS payment. The employer is then required to pay the employee the full grant received, and it's also important to note that HMRC can retrospectively audit any claims which have been made. Further question which comes up is what rights do employees have during furlough leave? It is critical to the basis of putting an employee on furlough that it amounts to a mutual change to terms and conditions of employment. Unless there are express layoff provisions under the existing contract of employment, the guidance is clear that these changes require to be made by agreement or should be made by agreement. Once an employee is on furlough leave, they have the same rights as they did previously, for example, to SSP, to maternity, to parental rights, to unfair dismissal, to redundancy payments if they are made redundant. The guidance does not specifically mention holidays, and it's a question which has come up. Our view is that holidays would continue to accrue. Certainly the statutory holidays under the working time regulations would continue to accrue as they did previously. What are the payment timescales for the grants? On the basis that the scheme will be opened at the end of April, it is likely that the first payments will be made by the beginning of May at the earliest, although the government has made it clear that the payments may be backdated to the 1st of March. Employers will therefore have to decide whether now to delay placing employees on furlough until the scheme is in operation, or to pay furloughed employees 80% of their salary until the grant is received, which will be backdated, or to place employees on a period of unpaid leave now until the grant is available. And clearly, every employer will have a different financial circumstance and will need to take a view as to which of those options they feel that they can implement at the current time. Whichever way this is done, it is critically important that the written documentation which sets out the basis of the agreement reached is clearly expressed and that careful thought is given to that communication before being issued. This is a variation to terms and conditions of employment, and how that is expressed and what is covered and how it will operate will be matters that you'll need to give careful consideration to. The scheme is specifically subject to existing employment protections, both under contracts of employment and under statute. Employers will require to engage carefully with their workforce, setting out, as I say, the precise basis upon which contracts are being varied and what payments are then being received and how this will be operated. I think it's also important to stress that where 20 or more employees are involved, this is also likely to trigger collective consultation requirements. And again, when looking at that, employers will need to weigh up carefully exactly how critical it is that they implement the scheme and over what timescale. If employees agree to the furlough leave, and many may do that because it is a much better alternative perhaps than being made redundant. If agreement is reached, then collective consultation is not required for that grouping. The collective consultation is required fundamentally for those employees who do not agree, as would be the case in any situation where an employer is seeking to make a change to terms and conditions of employment. So implementation and written communication should be carefully crafted, because what an employer wants to avoid is inadvertently promising to make payments for matters which are not covered by the scheme. And for example, it will be important that an employer is only promising to pass on that which is being recovered through grants. If you like, it could be seen a little bit like the way in which you might express a PHI scheme. An employer is only going to pass on the benefit which is being received from the insurer. And likewise, in this scenario, it'd be important that that communication is made clear that what's going to be passed on ultimately is what the employer receives by way of a grant from HMRC. The government has said that the scheme is in place for a 3-month period, but that it will effectively continue for as long as is necessary. One question which has been asked is whether employees who are on furlough can subsequently be made redundant either during or after the scheme has come to an end. And the answer to that is yes. Employees can be made redundant, although the employer would need to still follow through with the normal redundancy processes to ensure that that redundancy selection is fair, that proper consultation has been entered into, and to ensure that no liabilities are being created as a result. That is a run through the furlough scheme, and I think we now will go on to talk about the other issues which have been impacting on the oil and gas sector. And as I say, if time permits, we'll also try to come back to any questions which have been coming up and address those at the end if we can. So looking at the other issues which we have been advising on in the last week, one relates in particular to oil and gas being an essential or key sector. The Prime Minister's announcement on Monday evening to the nation, which now feels like many weeks ago, caused confusion amongst the business community which were not specifically identified as those who were directed to close, and those obviously were relating to sectors such as restaurants, entertainment and retail. Initial messaging from Westminster was that only essential businesses should remain operational as of Tuesday, 24th March, and that only key workers should attend their workplace if they could not work from home. The following morning saw pictures of crowded tubes and other methods of transport, taking amongst others construction workers to various sites. In the course of that day, the government advice from Westminster was clarified, namely that all workers should remain at home unless they could not absolutely conduct work from home, in which case they were permitted to travel to their place of work. On that basis, construction sites throughout England and manufacturing in many sectors continued, but we also had quite different operating procedures, which Lynne will come on to address. But further confusion was caused by messaging emanating from Holyrood on Tuesday. The First Minister stated in Parliament that if workers cannot work from home, employers should only continue operating their business if it was essential to the fight against coronavirus. Examples of making medical supplies or essential items of food supplies were given in Parliament as such businesses. On that basis, it was stated that construction sites in Scotland should close unless it involved essential buildings such as a hospital. A number of clients in the oil and gas sector, particularly those involved in manufacturing, asked urgent questions on Tuesday morning. Basically, and very understandably, could they continue to operate? And that was also against the backdrop that as of Tuesday, the Coronavirus Act had not been formally passed in Parliament, which meant that technically statements from the Prime Minister and the First Minister did not have legal effect. As of 26 March, the Coronavirus Act, which Lynne will mention, has become law, giving ministers significant power to make orders which have legal effect. This uncertainty has helpfully been clarified through OG UK liaising with government in both Westminster and Holyrood. And based upon that consultation, the oil and gas sector has been identified as essential for the supply of energy to keep the lights and heating functioning in our country. Clearly, those who work offshore will continue to do so, but in a different environment with appropriate risk controls, which Lynne will address. In addition, workers who have been designated as key by their employer may continue to work at onshore sites if they cannot also carry out their functions at home. From speaking to clients, we are aware of, in some circumstances, police officers making random checks at workplaces and even for those who have been commuting. We would strongly recommend that if individuals are attending onshore plants, manufacturing sites or offices, that they have with them a letter from their employer identifying that they are a key worker within the oil and gas sector. We understand that there are discussions ongoing, we believe, with Vantage in terms of which that system might be used for the purposes of issuing cards confirming key worker status for those who are onshore and travelling to workplaces, but that is still at the development stage. I'm going to pass on to Lynne now to talk about how these operations would continue to be conducted in the current environment where they are onshore in particular.
I have as Sean said, we're in very much a an ever-changing situation at the moment, and certainly at Burness Paull we are on top of all the advice and the changes as they come out, and are doing our best to get that information to you as quickly as we can. In relation to the oil and gas industry, there's a key role for the industry in ensuring, as Sean said, that the lights stay on. In responding to COVID-19, coronavirus, the industry have to ensure the health, safety and welfare of all of the people involved while maintaining safe operations and delivering that security of supply across the UK. In the last few weeks, we have seen that implemented by clients through local operational procedures and business continuity and resilience plans, many of which had not been used or seen for many years since the last flu epidemic. Government and healthcare agency advice, as Sean said, has been updated regularly with daily briefings from the First Minister, and in certain cases we've had differing approaches in Scotland. But we now have a situation where the Coronavirus Act has been passed unprecedentedly quickly through Parliament, and it's effectively enabling legislation, which was confirmed by a declaration of the Scottish Government yesterday, later on, that the Scottish Government now have the power to make regulations enforcing certain aspects in the fight against the virus, including social distancing, but it does go beyond that. The Act is lengthy. It extends to more than 340 pages, and we are going through the legislation at the moment. But what is interesting to note is that the power to make regulations extends beyond social distancing and includes the power to cause somebody for premises to be closed, and also for events and other gatherings to be shut down. And the special arrangements in relation to people and property extend to individual offences which could relate to directors and senior managers where there's been consent, connivance and neglect, and a failure to respond to a direction from the Scottish Government to close premises. So there's quite a lot of detail in that, and we're preparing an update which will go out today, confirming that in case it's of any interest specifically to our clients, because as Sean said, we have had queries over the last week around exactly that. And police, while at present the Scottish Police don't have the powers that their counterparts in England and Wales currently have, we expect that to change throughout the course of today when regulations are issued by the Scottish Government, and we can keep you updated on that. In relation to oil and gas specifically, the challenges for the industry are very much subject to change as we all move through the different stages of the pandemic. We've seen reduced manning levels onshore and offshore reflected in the requirement around key workers and essential business, as Sean has outlined earlier. For many of our clients, there has been a necessity to restrict work scopes to essential activities, and both roles within organisations have to be defined to identify safety and business critical roles, and including identifying vulnerable groups where risk-based decisions have to be taken relating to the risk of those individuals potentially being offshore during the pandemic, the need for urgent and immediate care and the availability of actually being able to provide that to any vulnerable person who was offshore if they were to get sick, and also the impact on business and safety critical roles and appropriate manning levels based on any vulnerable person who may be required to go offshore. In addition, all of these aspects have to be considered business-wide, and it's a huge management of change exercise that needs to be done to ensure that any business is operating safely, but particularly in the hazardous environment that exists offshore. There are major challenges around self-isolation and providing assurance for staff and workers offshore and how that's dealt with. There is now an official helicopter protocol which is in place to allow anyone symptomatic to be removed from offshore. But there's lots of challenges around that, and we're seeing it changing. At the moment, in relation to the Coronavirus Act and the provisions around enforcing social distancing and other aspects, I think there will require to be UK regulation to make the powers to apply offshore, but that's part of the changing environment that we need to wait and see, and we can confirm to you in due course.
Thank you, Lynne. We've also had a number of issues that have arisen specifically at the point of mobilisation to travel offshore. And I just want to touch on some of those in particular. Firstly, a number of important offshore workers reside in different countries and require to travel from their home country to the UK and then mobilise offshore. Previously, UK government measures placed restrictions with those entering the UK from designated high-risk areas known as categories 1 and 2. Those categories no longer exist and have been discontinued. Restrictions to travel offshore in circumstances where workers demonstrate symptoms in the previous 7 days or share a household with somebody experiencing symptoms within the last 14 days. They are the specific circumstances in which there is now restriction from government guidance. However, in addition to that, individual operators are risk assessing personnel and have imposed, depending upon their own views and operations, restrictions which will depend upon, for example, international travel in the last 14 days prior to mobilisation. And added to that, there may be restrictions for an individual returning to their home country and requiring self-isolation depending upon the rules in place at that location. That can give rise to a number of tricky considerations, and each situation will need to be looked at individually, whether the particular individual home country and operator requirements mean that the rotation is viable or not. If it isn't viable, the employer will need to consider various options, which may include varying the employment contract, paying reduced or standby rates, or potentially looking at furlough leave until matters are further clarified. We've also seen a number of testings that are now in place and developing rapidly at the point of mobilisation. Temperature testing is now commonplace at the heliport, and by its nature is not particularly invasive. There are recognised and agreed procedures which apply to that temperature testing. In addition, we are aware that some clients are either in the process of or carefully looking at coronavirus-specific testing, which is developing rapidly and is likely to be deployed pre-mobilisation shortly. We understand from what we've seen that this testing is likely to involve a blood sample and a rapid result being given on site within 10 or 15 minutes from the demonstrations we've seen. Clearly, that is an invasive procedure, and we would emphasise that informed GDPR compliant consent will be needed to be given, together with a clear policy from the employer regarding the testing procedure and what the implications are where the test is either positive or a person refuses. This form of testing and immediate results, in addition, give rise to various health and safety considerations, which Lynne is going to also address. Lynne, do you have any comment upon the testing that we're seeing coming through, and in particular, what might happen in those circumstances where there might be a positive test?
Yeah, I mean, it's certainly one of the areas where there are lots of issues. In the UK, we've obviously got the government position. OG UK has set up a pandemic steering group, which is leading the charge on managing a lot of the different approaches that are being taken to all of this. I think if someone were to test positive, there are lots of issues around what you actually then do with that person. How do you get them home? You know, if they've arrived and they are about to mobilise offshore and they test positive, and they're far away from home, how do you get them home? The protocol around that will depend on individual companies. OG UK are trying to ensure consistency of approach around that, but obviously anyone who tests positive will have to comply with the any of the regulations and the powers in relation to the Coronavirus Act 2020. And Sean, we've certainly had discussions around detentions for employers as to how far they go in managing that situation. I think we had an experience yesterday where an employee was put in a taxi and was trying to get home, having been found to be symptomatic. So it's causing lots of issues.
I think it's a good example where there are some very clear drivers where employers are and operators are very keen to ensure that testing is done. But as Lynne points out, thought has got to be given as to what the consequences and follow-on implications are, particularly where there's a positive test, and that there are arrangements being thought about to deal with that situation where somebody may have travelled, for example, a long way to get to the heliport. We've also been asked to consider various pre-mobilisation questions which are designed to confirm whether an offshore worker falls within the category of vulnerable set out in government guidance, or is residing in a household where a member is classified as extremely vulnerable. Now, these issues in turn are linked, and there are good reasons as to why an employer may want to ask those questions, because they are linked to both duty of care, but also there is the issue of the processing of sensitive personal data under GDPR. It seems to us that there is a clear legal duty and health and safety consideration in determining whether an offshore worker individually is a vulnerable person. And in our view, those sorts of questions would be justified. The normal GDPR requirements of ensuring that the data is processed in accordance with those requirements and who has access to it would be followed, but there are clear reasons as to why those questions should be asked. However, going beyond that to members of the offshore worker's household is less clear. Our advice would be to highlight that as an issue if the worker wishes to seek further information or to discuss on an individual basis. Making that a requirement to answer those questions as part of pre-mobilisation, in our view, could give rise to difficulties under the GDPR and the justification for that. Linked to all of this, given the increasing nature and tone of advice and the seriousness of the situation generally, we are aware that a number of workers who are either mobilising offshore or indeed required to attend onshore plants when they cannot work from home are expressing genuine fear and anxiety about attending work. Each of those cases will need to be looked at sensitively and having regard to each person's particular concerns. Giving access to occupational health or to topside medical support to discuss those concerns would be helpful. Employers should be careful before taking any significant decisions to ensure that there are no underlying health aspects, mental health aspects in particular, or disability status. In this situation, it wouldn't be uncommon for such a person to self-certify as being unfit to work on account of stress or anxiety, or to receive a fit note along similar lines. Now, that could give rise to an SSP entitlement and possibly company sick pay. I think in this situation, our advice is to be careful and to engage with individuals having regard to their particular concerns and to involve occupational health as being really key as to how you deal with a situation such as that. And do you have anything further to add in terms of some of the pre-mobilisation questionnaires and justifications for those, or anything else from a health safety perspective?
I think, Sean, the point that you make about mental health is a valid one, and that's obviously something which falls within the health, safety and welfare of any of your employees and the duties that you have in relation to them. I think where we can see difficulties potentially arising will be when the fear factor means that individuals may refuse or be disinclined to mobilise offshore. The knock-on effect of that could be that there's insufficient manning levels offshore to be able to operate safely, which could have big implications for operators and production going forward. But it's a complicated landscape because of the duties that you owe, and I think the advice that you've given around the caution and the piece around the questionnaire and approach to that, and having a policy around that is correct and is necessary.
Thank you, Lynne. And we've also obviously had now in press coverage and clear examples of individuals who have tested positive or shown signs of symptoms in an offshore scenario in particular, and where people are actually in that difficult health position. They are actually at work on an offshore installation. Yeah. Is that something that you want to add anything further to at this stage?
Yeah, I think it would help to do that just now. The as I mentioned, the pandemic steering group at OG UK, which is made up of a significant amount of members, I think they've recognised now that a large part of that needs to be distilled down to more specific groups. But there has been a huge effort in having the helicopter protocol agreed with helicopter operators, and we now have the unofficially named Coronacopter, where people can be removed from installations when they test. And it was agreed that there was policy required from OG UK around how to handle symptomatic and asymptomatic cases offshore, and that has been dealt with and put in place now. There is effectively a flow chart for people to follow based on whether or not someone is symptomatic and asymptomatic, and appropriate procedures to be followed by the helicopter operators in removing those people. Any arrival protocol and onward transportation is dependent on the individual companies. And Sean, we've already mentioned that there's the potential for tension there and issues around how exactly do you deal with someone who is either showing, particularly where they're symptomatic, with issues relating to the virus, and how those people are dealt with. There are certain companies and businesses within the industry who are handling it in different ways, but that is very much a work in progress, and OG UK have been quite clear this week that they are continuing to discuss how that can be managed both with the industry and with the government. I think it's quite clear that if there's a confirmed case offshore, then it will be a lockdown situation, but the stage that we're at the moment is very much based on identifying potential cases which may be symptomatic or asymptomatic, and removing them from any installation and then dealing with them onshore.
Thank you, Lynne. Lots of extremely helpful points there, and situations which are sensitive and need to be dealt with on a case-by-case basis. But we do have some time to now deal with some questions which have come through, and we'll try very much to get through those. First question which I'm going to address is, can somebody be made redundant whilst on furlough? Thought they were protected during this period. The answer to that question is that employees can be made redundant either during the period of furlough or at the end of it. They are protected in the sense that they have an entitlement to a redundancy payment in those circumstances and to receive any notice under their contract of employment. And they're also protected if they have more than 2 years service to make a claim for unfair dismissal. So an employer would need to ensure that they go through processes carefully and make sure that liabilities for unfair dismissal are dealt with, so that any payment is just for the redundancy and the notice. Another question which has been raised similar to that is, would redundancy payments be calculated on furlough salary or previous terms and conditions? It's a good question. It's not specifically referenced in the guidance, but my view is that it would be calculated on the basis of the previous terms and conditions, because those are the terms and conditions to which the employee is normally employed, and these are varied terms which are applying for a particular period, and at the point of termination, the redundancy payment calculation should be on the normal terms and conditions.
There's an interesting.
Sorry,
I was just going to say there's an interesting question that I've seen just come through, Sean, where someone is asking, they have a number of employees now saying they feel they are at risk by coming to work and wish to stay at home. Can these individuals be furloughed?
Very good question. So the key issue there is whether or not there is still a requirement for those employees to be working, because the essence of furlough, if we look at it, is that persons being put on furlough as an alternative to redundancy. So if you have a situation where there's still a requirement for the work which the person does, but they have an individual fear regarding attendance at work, there's still a requirement for them, that job to be done. So it wouldn't be appropriate to be using furlough in those circumstances, in my view. It would be appropriate to be looking at that individual as to whether or not they are actually capable of going into work and what the actual medical position would be underlying that.
In relation to the risk piece, one of the things that we didn't mention that we have spoken about between ourselves, Sean, is the importance of communication with the workforce around any measures that have been put in place to ensure that they understand how the risks are being addressed and managed, and give confidence to the workforce that that is being done. I mean, there's requirements under the health and safety legislation for consultation with employees about any measures that anyone has put in place in relation to mitigation of the risks of the virus. But I think the communication point here is another thing that's quite important in managing that risk and fear factor.
I think that's absolutely correct, Lynn, and I think I would also add to that, having access to employee support programs, to occupational health, so that those aspects can be discussed, and also presumably as well, as you say, sharing information about how risk mitigation is being looked at and how workplaces are being assessed, so that those fears can be allayed. Lynn, another question which has come through is somebody said that currently they have a bus to transport employees to site and lots of car share, and any particular views on the approach there, and how you might get to employees to site who are key workers in those situations?
I think in those situations, you have to make sure that you can comply with the social distancing guidance that's being issued by the government. So in relation to any bus, for example, you would have to make sure the 2-metre rule could be adhered to in any seating arrangement. And likewise, for any car share, the importance there would be to ensure that you don't have too many people in the one car, and again, able to comply with the social distancing aspects. Enhanced hygiene is a huge part of the mitigation and response to the virus. So you would want to consider also, again, facilities for hand washing in relation to getting on and off of transport before you're doing anything else, particularly where you've been more proximate to other people.
Yep. Another question which has come through is, if an employee is on furlough leave and then subsequently becomes sick, would they then be entitled to sick pay, SSP, and potentially company sick pay, and no longer receive furlough? The answer to that is that a person's status may change, and that is permissible. So I mentioned that if a person is has an entitlement to SSP, they are excluded from furlough. So the scenario there is that if a person becomes sick and has an entitlement to SSP, their status would change from furlough leave to sick leave and then have an SSP entitlement. But at the end of the SSP period, or the period of sickness, if the person's situation hasn't changed in terms of the work requirement, in other words, there isn't a requirement for them to be at work, then their status moves back to furlough. And so I can see there could be, some complicated calculations required in some of the HMRC submissions for the grant, but it is possible for a person's status to switch from one to the other.
I've just seen an interesting question, Sean, that I think you might be able to answer in the time remaining. How can you maintain social distancing during a redundancy consultation process if the individual is self-isolating?
Well, that's an excellent question, and I take the view that when we look at these sorts of situations, and particularly when we look at redundancy processes, the key word is acting reasonably, and reasonably depends on the circumstances. And so, given the current environment, and given the very, very clear messaging that's been and advice, my view is that redundancy consultation would be reasonable to be conducted by telephone or by Skype or something equivalent. I don't see that there would be an employer that would face much criticism for doing it in that way. It's a good, effective way of communicating. It's the way in which we're all communicating, and yes, it's a sensitive issue because a person's employment is at risk, but it would be a very, in my view, reasonable way to conduct consultation in the current.
Thanks.
I think we've just hit the 1 hour mark. Can I thank you all for attending and for all the questions which you've been putting through. I'm sorry that we perhaps haven't had a chance to go through them all, but we will certainly take those away and we will address them in a separate advice note. And on that note, we will sign out and hope that you all have a good and safe rest of day. Thank you.
Thanks.